एक बार फिर रुख कर लेते हैं सुप्रीम कोर्ट ऑफ पाकिस्तान का, जहां पर प्रैक्टिस एंड प्रोसीजर एक्ट केस के हवाले से समाअत जारी है।
8303, which addresses the questions which were raised.
Both need to be read.
Yes, ma'am.
Okay.
So this 8303 addresses the questions which were raised when I made submissions on the first hearing.
So you are saying that you will not repeat everything, but you'll highlight only certain points.
Absolutely, my lord. I think that is only fair. I mean, to save time, I'm not going to repeat what I've already.
You will not repeat everything, but you'll highlight only certain points.
Absolutely, my lord. I think that is only fair. I mean, to save time, I'm not going to repeat what I've already written. I'm only going to focus on the questions which by now everyone is fully aware of and which need to be addressed, including the question that I owe to Ladyship Justice Aisha Malik on full court. I have addressed that question in the written submissions, but I want to make few submissions on that.
Please proceed in your own manner.
My lord, and as far as maintainability is concerned, because I have submitted that competence alone cannot be challenged in proceedings under Article 184(3) unless it can be shown that any fundamental right has been affected by the legislation in questions. Therefore, when I make submissions on Article 199 and I address independence of judiciary, those submissions should be treated as having read, treated as my arguments on maintainability. I now, my lord, proceed to Article 191. My lord, three questions have emerged, essentially. And my lords may add if I missed out on something. First is that the principle of Master of Roster is a convention which is rooted in over 150 years of judicial history of the Indian subcontinent. Therefore, and the petitioners had relied upon Malik Asad's case and Al-Jihad case to argue that because it has attained the status of a convention, therefore it has to be treated as part of the constitutional provisions, and thus this legislation could not upend and could not change the status of the Chief Justice as Master of Roster. So this is the first question that I intend to address. The second, the 1956 rules, which were in force at the time of commencement of the Constitution, ought to be treated as existing law. And for the purposes of the term law under Article 191, those rules should be treated as the law, and thus the Parliament could not legislate on that matter because of those rules having the protection of Article 268. So this is the second question that I intend to address. Third, and this goes to separation of powers as well, and it was observed yesterday that Parliament has assumed the role of Master of Roster through this legislation.
Sorry?
This question, that Parliament has assumed the role of Master of Roster through this legislation. So this is the third question that I intend to address. And then, of course, I'd be addressing the right of appeal under Section 5 on the basis of Entry 55 to argue that it is constitutional.
Right of appeal on the basis of?
Right of appeal conferred under Section 5, the question on constitutionality of it, so I intend to address that on the basis of Entry 55, sir. Entry 55. To argue that there is no prohibition under the Constitution to enlarge the existing jurisdiction of Article 185 and extend to judgments and orders arising under Article 184.
सब्सक्राइब करें और बेल दबाएं ताकि कोई खबर रह न जाए।